First one's going to be Mari. Mari is our Pegasus legal firm attorney.
My name is Mari Willow. I work at Pegasus Legal Services for Children. I'm one of the staff attorneys, and I primarily practice in the area of guardianship. We're a nonprofit legal aid who practices in a variety of areas of law involving children.
Okay, next, of course, we have Derek. Derek is from New Mexico Legal Aid.
Good afternoon. Yes, my name is Derek Garcia. I'm a staff attorney at the Albuquerque office of New Mexico Legal Aid. I work 25% of my time with the Kinship Guardianship Caregivers Project and the CYFD partnered agencies. I devote 75% of my time to a project called Safe to Be You, which is also a statewide project through the Office of Violence Against Women in the Department of Justice, a federal project that provides free civil legal services to survivors, LGBTQ survivors of domestic violence and other forms of violence in the LGBTQ community. So I work quite extensively on cases involving kinship guardianship in that sector and arena, and as well as in domestic violence related situations. New Mexico Legal Aid generally serves the entire New Mexico community, and because we are dedicated to opening the door to equal access to justice across New Mexico, we are very, very, very grateful for the opportunity to connect, even deeper into communities that we haven't reached, especially in rural and other sort of sectors that often get overlooked. We generally have about 14,000 persons per attorney at New Mexico Legal Aid that are potentially eligible for service. So a lot of the services that we do provide in the kinship arena, we're just gearing up with, just joined the project, and very grateful to be there. We try to provide at least advice and counsel telephonically or more extended services, including direct representation on very select cases. So good to make your acquaintance, and I look forward to helping individuals out if we connect as attorneys and clients. Thank you.
Thank you, Derek. All right, our next one is going to be Vanessa Peak with Peak Law Firm.
So my firm, actually, I'm a private attorney here in Albuquerque, and I do actually mainly family law cases with a special focus for the Hispanic community. I do work with kinship guardianships, but also I do specialize with divorce, custody, and pretty much all the domestic matters issues that we deal in family law.
All right, thank you, Vanessa. And our last one is Esther from DNA Legal Services.
This is Esther. My name is Esther Kiesler, DNA People's Legal Services out of the Farmington office. We have offices all over the Navajo Nation, including Flagstaff, but our office is the only one in New Mexico now. There was a Crown Point office, but it was closed. So we cover a big area of San Juan County, Rio Arriba, Sandoval, and part of McKinley County, because they're part of it on the Navajo Nation. So we do a lot of kinship guardianship in the Navajo Nation courts. We haven't really been doing much in the Hickory Apache court because they don't have kinship guardianship in place there. And then our attorneys, they also do pro se kinship guardianship classes like once a month before the pandemic. So right now we're just at a standstill now. I try to help everybody now, even they call in, and we try to give them like pro se packets when need. We really haven't gotten any referrals from CYFD yet. So these are just a lot of it, just word of mouth, I guess. So we do a lot of that, and we also do a lot of the caregivers affidavits for school and medical for grandparents or aunties and uncles that need that for their nieces and nephews. So that's us. I have 3 attorneys in our office myself. I'm licensed in Navajo Nation Court as well as a Hebrew Apache. And then we have 2 support staffs in our office.
If the father of the child or children is not on their birth certificates, what rights do they have, if any?
In New Mexico, you can become in state court. So like Esther said, she practices in Navajo court. So I think the answers are going to be different depending on what jurisdiction you're in. But in state court, you can be a father in a number of ways. So in kinship guardianship cases, you must serve the father, and that can be the biological father or a legal parent. So for example, if you know the name of the father, you know where he lives, you know he holds himself out to be the father, he needs to be served. If you don't know who he is and he's not on the birth certificate, then he needs to be served, usually by newspaper publication. But that's just a general explanation of parents. And I think different attorneys interpret this differently, but generally, if you know who the father is, the father has general rights to the child, just like the mother does, regardless of whether there's a finding of parentage or the father's on the birth certificate.
Through the Navajo Nation, I don't know if you want to hear that too. If your name is not on the child's birth certificate, you are a stranger to the child. You have no legal right to the child. That is a Navajo Nation Supreme Court opinion. Unless you go into court and say, hey, I'm the father, and you file your petition for paternity, and that's the only way you'll get recognized as a father. If the father is wanting to get custody, they have to establish paternity first. Otherwise, they have no obligation to pay child support or nothing like that, according to the Navajo Nation Court's Supreme Court. But however, the mother can also establish paternity just the way that the state court does, take them into court and then establish paternity. One of the things that's very important there is to serve him. So you have to know where he's at, and you got to know who the father is.
In regards to just the rights of the parents, the father, I will say that here in the 2nd district and what I've seen in New Mexico in regards to not so much the kinship but parentage cases, fathers do have the right, but like in the Navajo Nation, the parents father have the rights, general rights like the mother, but they do have to request to the court if they want to have some sort of like custody or time sharing, or to be required to pay child support. Because if a father calls, let's say, and it's not in the birth certificate, call the cops, the police will not enforce anything if there is not a court order adjudicating that person as the father.
In state court, yes, they have the right to notice and to potentially be heard at the very least. I've had a case where the biological mother did not know who the biological father was. We, would have gladly provided notice of the pending proceeding to appoint the kinship guardians, so that biological father, presumably out there somewhere, could potentially contest that. But the court in that particular case did not require us to, serve by publication generally, because the father was just generally unknown to the biological mother, who was consenting to the appointment of the kinship guardianship providers. So at the very least, just to echo, they have the right to notice that the proceeding is going on. And beyond that, they can choose to appear in court, and they may be, just to echo, ordered to pay child support or visitation schedule if they're going to contest the appointments of the kinship guardians past that point. But there is process involved.
If you feel that a parent won't agree to kinship, how do you proceed? When
the biological parent is on board or is wavering and kind of unsure about what it exactly means to be relinquishing, parental rights across the board, our typical first step is to really negotiate with that parent and really reach out and to explain and answer questions, as the attorney on behalf of the petitioners. And so I would say as a general answer to that question, allow some time for us to be able to contact the biological parents and make them more comfortable with potentially filing the necessary consent form, which makes it an uncontested proceeding, and then it goes forward a lot, quicker and more, and with less friction for all family members concerned. So yeah, it's a process, a very human process, just like any other. Just getting on the phone with those interested parties, the biological parents and their counsel, if represented, and negotiating to see if we can, rest assured that if there are agreements that can be made regarding visitation and that sort of thing and negotiated, then we don't have to move forward to a fully contested proceeding. And usually the hangups, surround, well, I'm never going to get to see my child again, that sort of thing. And in those cases, it's very easy to, with your client's consent, to offer, reasonable visitation and that sort of thing as part of obtaining their consent for the appointment.
Yeah, and in addition to that, in state court, you can either get the parent's consent or you can give the parent notice. So you have to serve them legally. And the two most used ways, I think, for service in New Mexico is personal service, somebody handing the documents to the parent, and or certified mail to their house, which they sign for. And then that person is then entitled, the parent is then entitled to show up in court or respond, but they don't have to. But what the petitioner, the person asking for guardianship, has to show is that the parent is unable or unwilling to provide adequate care, maintenance, and supervision for the child. And so it doesn't matter whether the parent agrees or not. The other thing is when a parent contests, when they come to court and they disagree that a guardian should be appointed, the court is mandated to appoint a guardian ad litem, which is an attorney that acts in the best interest of the child. And they're sort of like an investigator for the court, and they help the court decide what's in the child's best interest. So
if somebody was going to go through this process, the key word would be, if they were talking to a legal counsel, like, following up, actually sitting down with somebody, they would say, I want to contest this and I'm looking to get in the process of getting a guardian ad litem. Is that the key word?
Sorry, you're talking about the parent?
The caregiver.
The caregiver would not want to contest the guardianship. They're the one asking.
Oh, I'm sorry, asking. I'm sorry.
No, it's okay. So I just wanted to clarify the question. So they don't have to ask the court for a guardian ad litem. The judge will appoint that.
The judge will appoint it. Okay.
What they have to do is provide notice to the parent.
Provide notice.
Right, okay. And the ways they can provide notice is certified mail. So they send certified mail with every filed court document inside of it, as well as a summons, which is like a document that says, hey, parent, a case has been filed. Here's the case number. If you want to respond within 30 days. And then they can be served via personal service, either through any adult over the age of 18 who has a valid ID, who signs a document like the summons return in front of a notary that says they were served, or the sheriff oftentimes will serve. And if you're eligible for free case filing, you can have the sheriff serve for free in the county where you live, county where the case is filed. When the parent's unknown or unavailable for some other reason, you can serve via the newspaper, but you have to get permission from the judge. So it's a bigger hurdle.
The process of service to the parent is basically almost like New Mexico's in the Navajo Nation, and as well as the Apache court. Yeah.
Say a parent misses numerous visits and disappears for weeks at a time. Will the judge still apply a visitation schedule when and if guardianship is appointed and approved?
I mean, in my opinion, the answer is always maybe. right? We don't know what the judge is going to do. They're the ultimate decision maker. So if the person asking for guardianship, the petitioner, wants visitation to be stopped, they need to make an excellent case, because visitation is like the minimum parental rights, right, that a parent can retain. Or there's other ways to have visitation. So you can do supervised visitation through an agency. You can do counseling between the parent and child. You can suggest something that's less than the visitation schedule that's been happening. But certainly there are ways to convince a judge that visitation is not in the child's best interest, or that the parent's failure to show up every time is affecting the child. Like what I always suggest to my clients is that they write down the date that visitation was agreed upon, what happened afterwards, whether the parent showed up or didn't show up, how much notice was given, whether the parent asked to reschedule, whether the child was upset after visitation or happy, things like that.
I would completely agree with that. Also, it really just depends on your judge, your decision maker, and the other factors, whether or not some form of emotional abuse may be occurring. If the child has, scheduled visitation, that needs to be considered. Certainly in those cases, there's good grounds to, withhold visitation and that sort of thing. It all depends on the facts and circumstances, the very, specific case and the very specific decision maker. Very rare that any legal situation will have like a 100% certain this is what the judge is going to do in those sort of situations. So you'll definitely want to, at least try to seek advice and counsel of an attorney on how to go about navigating that process, and at least mention to the, go through various options in terms of limiting visitation, supervised visitation, as well as, other mechanisms which may be available to make sure that the child isn't, or children are not experiencing harm.
So the question, basically what it is if I'm applying for kinship guardianship, but someone else in the same family is also applying for that guardianship, how do we go about that? What are our options? Basically, I'm one person, and then there's another one that's also trying to obtain that guardianship.
Well, the kinship guardianship was actually created, the whole intention of legislation was to provide to the children a stable environment, to be living with someone that has a relationship. When the parents cannot provide that to them, a guardian can give that to them, that stability. So the courts really will, what they're going to be looking at, it's a different factor, but the most important thing will be the best interest of the child and who the child is residing with, who the child is closer to, because may say that the child has a close relationship with maternal grandma, but paternal grandmother also wants to have the child, but has never seen the kid, only talk with him over the phone, and the child is not used to her. Most likely the court is going to lean to give it to maternal grandmother, because that's where the kid is. It's a safest space for him or her, and it's in the best interest for the development to be with someone that they are used to, and they have a closer relationship too.
Yeah, and the other thing is about that, before filing, the parties have to meet certain requirements. So the person asking the court to appoint them guardian has to either have the child in their home for 90 consecutive days prior to filing without any unconsenting parent. So, if I have my brother's child in my house for 90 consecutive days and I'm acting as that child's parent, then I could then go to the court and petition for guardianship on the 91st day. The other ways that you can petition for guardianship is to claim that there are extraordinary circumstances and the child's been something, it has to actually be extraordinary. Sorry. So it can't just be like, my brother didn't enroll my nephew in soccer and he really wants to do soccer. It has to be something like probably pretty close to abuse, neglect, or we generally do it when a parent is incarcerated or they've passed away or teenagers run away from their home. Otherwise, you have to wait the 90-day period before filing. So if one grandparent has the child for 90 days and files for guardianship, and another grandparent doesn't have the child at all, there's an argument to be made by the grandparent who's had the child for 90 days that they're the only one entitled to file for guardianship.
Yeah, just to add to that, I haven't had the particular case where you have dueling petitioners. Usually, if there's any, contests, it's between the biological parents and the kinship caregivers. So I would say, it's why, conflicts of interest and that sort of thing are very important for the attorneys, to make sure that all interested parties receive notice, but then, one petitioner will, link up with various attorney maybe to handle their filing and make sure that in the petition itself, other potential petitioners are also listed so that they can obtain counsel for themselves and participate in the proceeding. And then it really boils down to the judge's decision on what is best for the children, in addition to the 90-day factor where the child has been physically residing for the previous 90 consecutive days, as well as who's economically sort of in the best interest of the children also to provide the best and most appropriate care. So yeah, I think it's really it all depends on the facts and circumstances, again, with that sort of situation, but very important that all interested parties receive notice and an opportunity to be heard in the proceeding.
There was another question here in the chat where it said basically that the caregiver had the custody of the children for at least 5 months. The bio father did not meet the requirements basically to do meetings with the kids. The caregiver has a caregiver certificate, and now I guess the father is wanting to communicate with the kids, but the caregiver rather have a mediator kind of dealing with all of that. What are her options, or how does she go about that?
In order to get guardianship, you have to go, a judge has to give it to you, a district court judge, after you file paperwork in court. If you don't have that, there's some lesser things you could have. So something that Esther mentioned is a caregiver's authorization affidavit and power of attorney. So a power of attorney is something signed by a parent, a document signed by a parent who has custody of a child to let another person enroll that child in school and make medical decisions for them. But it's revocable, meaning, like, again, if I have my brother's child living in my house and he signs a power of attorney for me, and then he decides, okay, today I'm going to do it, and then I make him upset, and tomorrow he picks up the child, he didn't do anything wrong. His power is revocable. Or if he continues to leave the kid in my house but takes away my power of attorney, he can also do that. All it does is allow another person to make medical decisions, or even if I have 2 children, I can give a power of attorney to my sister to allow her to take my child to the doctor on Tuesday, even though I don't give her my child. Okay? And at any point in time, I can call the doctor, or I can take that paper from my sister. Caregiver's authorization affidavit is generally used when you cannot get a hold of the parent who has custody of the child. So let's say my brother drops off his son, he leaves town, and I'm like, I need to take this kid to the doctor. What do I do? I can sign the caregiver's authorization affidavit myself, swearing that I'm taking care of this kid, and use that paper to access medical care. But if he comes back 3 weeks later or calls the doctor and says, no, she can't do that, then I can't do it. What a judge does in a guardianship proceeding, when the order is given, either a temporary order, which lasts 6 months, or a permanent order, which lasts until the child turns 18, or unless there's a further order modifying that, what it does is it suspends the parent's rights. So while the guardianship is in effect, the parents have no rights to the child, no rights to make any decisions unless the court says otherwise. And then at that point, the person who has custody of the child, so the guardian, then has like custody of the child, gets to make all the decisions. So let's say I get guardianship from a district court judge in the county where the child lives, from like an order, right? And then my brother contacts me and says, hey, I want to talk to my son. Okay. On the final page, there's generally a line in there that says either visitation is at the discretion of the guardian, or it says something else. It says mom should have visitation every Wednesday for 3 hours, or the father should have no visitation until he gets a psychological assessment, blah, blah, blah. Whatever that says, that's what the rule is that applies. So if it says visitations at my discretion, I could tell my brother, hey, you know, if you're not on math tomorrow, you can come to Johnny's birthday party. But if you show up and your eyes look all glazed and you're acting crazy, you can't come, you know, kind of thing. So it just depends on what the judge has stated in the order. And it's at the discretion of the guardian. However, if you're given guardianship, it's at the guardian's discretion, and the guardian is being unreasonable with visitation, that's when the guardian is going to get in trouble. So if I'm just saying like, oh, you can't come by because, you know, we don't like you, we don't want you around here, or whatever, that's not a good reason. It needs to be a valid reason. Or that parent can come back to court and ask to modify the order. Say, judge, like, they won't let me see my kid, I don't know anything about them, blah, blah, blah. So again, it's up to the judge, it's situation dependent, but read what the judge has said if in fact you have a guardianship order. And if you don't have a guardianship order, then you know, the parent has all their rights and they can do whatever they want. Regarding the child, the other common question we get is if the order says dad should have visitation every Wednesday for 30 minutes, and then the dad wants more visitation, you don't have to go back to the judge and say, we want more visitation. You can just give it. What the judge lays out is the minimum required.
Yeah, I'll just add on that it's very, very confusing for a lot of folks out there to understand the differences between what the parties may have agreed to out of court in a power of attorney document, which is, you know, as Mary pointed out, easily revocable by the granting biological parent at any time. And then their parental rights, you know, sort of trump that document, even if it was in place as a temporary arrangement between the parties, or the caregiver's authorization is also dependent on that person providing their consent at the time they could be noticed and, you know, sort of brought into the, you know, situation. So it's very confusing, and it all depends on what's already in place. But the caregiver's authorization, power of attorney, if it's not granted by a judge, most likely it can be undone by the parent. And the only way around that is for the petitioners to go into court and actually get rolling on the petition for the permanent guardianship. At that point, the judge will usually issue a judge-ordered 6 month temporary guardianship, and allows, you know, the visitation line, as Mari was explaining in the very bottom, to, you know, say exactly what visitation should be occurring in 6 months, pending a GAL being brought in, pending further court proceedings, and then usually a final order on order appointing the kinship guardians. And then it becomes generally, you know, they take the place of the biological parents in terms of all their rights. And usually it's then their discretion on visitation and custody and that sort of thing. So it all depends on which stage of the proceedings you're in, whether or not you have a temporary power of attorney document that's based on the parent's consent, whether or not it's a caregiver's authorization if you haven't been able to locate or notify the parents. You know, those are easily undone. Not so with the permanent guardianship or the temporary order when you're actually in court. So I would say, you know, best to consult with an attorney as soon as possible if it does look like it's going to, you know, result in a lot of conflict and potential harm to the child.
If a guardian already has like paperwork in place, and a bio parent who was like not in the picture comes back up, what would be the next step in that case? Who's wanting to be involved in the child's lives, but the guardian has already had these children for a while? What would that look like? What does the court say? How does the process go?
Yeah, so it's really dependent on what precise paperwork is actually in place. If it's merely a power of attorney, that can be undone by the biological parent at their own discretion at any time. and it's not really, up for debate if that person, they have their full biological parental rights, decides to come back in the picture and undoes the power of attorney that they have. The only recourse is to go to court and file the full petition for kinship guardianship and initiate court proceedings. If it's a caregiver's authorization, same thing holds true with that, document. Generally, if the biological parent's been out of the picture and that paperwork allows, that temporary person to assume the duties and responsibilities of the biological parent, that can always be undone by the biological parent. However, if you've already been in court, if you've already been in front of a judge and received a temporary order on kinship guardianship, that document cannot be undone by the biological parent without further proceedings. And the judge's signature saying that such and such visitation is appropriate, or the temporary guardianship is hereby terminated. And usually that gets granted right at the initiation of the kinship guardianship proceedings in court. Likewise, if the paperwork in place is the permanent order granting the petition for kinship guardianship, in those situations, it can't be undone very easily by the biological parent coming back into the picture. It's been done. To undo that process requires a lot of legal legwork on behalf of the biological parent, and it's a much more permanent situation. In fact, 98% permanence in most cases. So yeah, it really depends on the precise paperwork in place and the facts and circumstances and where we are in the procedural posture. So I would say the best advice is to run it by an attorney for at least some telephonic advice and counsel in that sort of situation, and decide exactly what needs to be done.
One simple way to remember it too is that if a judge gives it, if only a judge can take it away. If a parent gives it, the parent can take it away. So that's just like a simple way to remember.
Yeah, that's a very good.
Who has the authority?
And maybe we could talk about some support that for guardians who are needing help with paperwork.
So my office does not, I don't want to say we don't help with paperwork, but if you call my office and you say, I need help filling out that packet, you're not going to get that. The way that our procedure works at Pegasus is we have a general intake line. The phone number is 505-217-1660, or you can just look us up and call the main line. But the intake specialist will gather information about what you're calling about to make sure we can assist, and run a conflict check, which is something we have to do, make sure you financially qualify for services. And at that point, they'll gather information about your case in the same phone call. It's around like maybe 15 to 30 minutes, this call. And then the intake specialist will get the information to an attorney, and the attorney will determine the level of advice that that person should get. Sometimes we assist with specific questions about the paperwork. So if a person doesn't know what to write in regards to, say, the parent, like who's the father, or they're confused about the requirements or the next step, we can answer those questions if the person qualifies for our services. But what we try to do is provide full representation, meaning that we draft all the paperwork for the guardian, we file it in court, we do all of those things, but we can't always move at the speed that the guardian needs. So sometimes we have 12 callbacks every week with an attorney live on the phone for people who qualify for our services to get additional information. But also sometimes the courts have self-help days. That's a little bit off because of coronavirus. There's also private attorneys who might be able to assist just with paperwork, but generally attorneys like to provide full representation because there's a lot of things that can change throughout the case. It's not just paperwork. If it was just paperwork, it would be easy. It's a lot more than that.
From New Mexico Legal Aid, we generally also have to run, conflict of interest checks before the attorneys can even talk, with you when you're calling. And we also gather a lot of your personal information to be sure that the reviewing attorney understands the full facts and circumstances of the situation completely. We are authorized to give general advice and counsel over the telephone, and for assistance in, assisting you to fill out your own paperwork and file in court yourself. And on a very limited basis, we can also provide a potentially direct representation in court to be your actual attorney. But the main factor is we have to gather your information and research the case as much as we possibly can before providing advice to you on how to fill out the paperwork. And as Mari pointed out, there are often very changing circumstances in these cases. So we have to be very, very careful about, the advice that we do provide. Generally, however, if you have questions about paperwork and what specifically to say, I would say the best way to do is to, apply for the legal services. We can take applications online through New Mexico Legal Aid, all one word, spelled out, .org. So New Mexico spelled out, New Mexico legalaid.org. There's an online application as well as an apply for legal help by phone. And that number is 1-833-545-4357. And you'll be transferred to our intake unit who will gather your information fully and then be reviewed by one of the attorneys who may be able to assist you. And so, we offer also brief services in terms of helping with underwriting, legal paperwork, but it all depends on the facts and circumstances of the case. Some cases that are contested are too much for us to be able to provide advice and counsel. If we know they're contested cases, we usually like to do full representation on those cases too. And it really depends on our resources and time, depending on the cases that we've previously committed to. The best way to receive even, some brief advice over the telephone is just to give us a call, and, we'll definitely assess that as much as possible. And please mention that you're part of either, Families Fostering Family or Southwest Family Guidance Center or a CYFD partnered agency, and working with these projects. That way our intake personnel ensure that it gets to the appropriate channels for review. We often require members from the general public to be income qualified also, which doesn't apply in this particular partnership agreement. So be sure to mention which agency or which where you're calling from, in other words.
And I would like to talk a little bit more on the side of the private practice, not like nonprofit organization, but the private attorneys. We understand that there are some cases that are highly litigated or complicated or circumstances changes, but also we understand not just on the legal case and the legal facts, but also the life of that person that is presenting these legal facts. Sometimes their income is not high enough to pay a private attorney, neither low enough to qualify to a nonprofit organization. So these people are in the limbo. And what can you do with this type of cases? I think that private attorneys, there is a type to work with this type of situation, and it's called unbundling services, which is, it's pretty much dividing the entire process, and you are able to just hire an attorney for a specific piece of your case. Yeah, I understand that it's a little bit difficult with cases that is going to require more litigation, but sometimes you just need to bring that petition to the court and you're completely lost and you don't know what to do. And I think that it's an idea that maybe a private attorney, you can have an initial consultation and contact to this person and may be able to kind of point you out as to how to fill out these documents. And then after that, maybe it will give you a little bit more time to apply to a nonprofit organization, to look for other resources, or maybe to start looking for these unbundling services. I guess that's my point of view from the private sector, is that there are options that even though the case will be complicated, sometimes you just need to bring that petition to the court at that point. And that's the only thing you can afford at that time.